Welcome to our HR Community Update. I'm Byron Decato, Director of State Civil Service.
And I'm Sherry Gregoire, General Counsel.
Today, Sherry and I are going to give you an update on parental leave. With the support of the Civil Service Commission and Governor Edwards, parental leave will be available to classified employees effective January 1st of 2024.
And leave will also be available to unclassified employees through the Governor's Executive Order effective January 1st, 2024.
HR professionals should refer to both the Civil Service rules and the Governor's Executive Order for more information about these parental leave rules. So during this update, Sherry and I are going to share with you some resources that the department has put together for our HR professionals that can be used to share with employees and also help you in administering these rules. This is not intended to be a training, as we have provided training prior to our commission meetings and also during our commission meetings. So today we're just going to be real informal. We're going to share what the department's put together. We're going to show you our webpage, and we're going to hit some of the highlights of the frequently asked questions that we feel that you need to know about. Sherry, if we navigate through our website, if you go to civilservice.louisiana.gov, you will find our main website, and you will click on HR Professionals at the top of the website. Once that comes up, you will see we have a dedicated tab for parental leave resources, and that will take you to the parental leave homepage. Here you will see a number of things, and we will continue to update this as we have updates available. On the left-hand side, you will see we have our parental leave home button, and then we have general circulars where we will include all general circulars related to parental leave and the administration of the rule as it is rolled out. We have parental leave FAQs that Sherry and I will get to in a minute. And in addition, we have our documents and templates. Here we have a certification form that Sherry and I are going to get into in a little bit. And then also we have some templates for approving and disapproving the leave, and we'll get into that as well. And then also to contact us, simply click contact us and we will answer any questions that you have. But the first thing that you will see, we have a downloadable one-page infographic on parental leave. We highly suggest that you share this with your employees. Maybe it's something that you can use in the onboarding process, or you have departmental meetings or staff meetings, encourage your supervisors to share that with your employees. That way they know what is available to them on January 1st of 2024. So before we get into the FAQs, we'll just recap real quick, Sherry, what parental leave actually is. So can you tell us a little bit, Sherry, about what parental leave is?
Sure. Parental leave is an opportunity for employees to bond with a newborn, or for parents who have adopted or fostered a child to bond with that child. Parental leave also affords the opportunity for parents who are adopting or fostering a child to attend court proceedings or meetings related to the adoption or the fostering of the child.
So who is eligible for parental leave? Legal parents, adoptive parents, and foster parents who, 1, have an active and ongoing role in parenting the child, 2, are in a leave-earning position on the date of the qualifying event, and 3, have worked for the state for 12 months and at least 1,250 hours in the 12 months immediately preceding the date parental leave begins.
And how long is it? A full-time eligible employee may be granted up to 6 weeks, 240 hours, of parental leave during the 12-week or 84-day period following a qualifying event. The number of hours an eligible part-time employee may be granted will vary depending on their work schedule.
And is it paid? Yes, the employee is entitled to compensation at the rate of 100% of their base pay while on parental leave. So now, Sherry, we'll take a look at the frequently asked questions that we put together. If you go to the left-hand side of the page and click on Parental Leave FAQs, you will see we put a number of questions here, with the caveat that if you do not see a question that you sent us listed, or if you have an additional question, please contact us and we will do our best to get this information on our webpage as well, because we want to make sure that we answer all the questions that our HR community has. So the first thing that you will see is what is the intent of parental leave. And Sherry, I think we covered most of this already with our update. Some of the things that I kind of wanted to just point out here for intent was that it is to be used effective January 1st, 2024. We've gotten a lot of questions about that.
Right. We've had a lot of you ask, what if I have a child right before that? Or what about the current qualify right after that? You have to qualify on January 1st, 2024 or after. An event that occurs before that is not going to qualify for parental leave.
Right. And then who can use it? We also covered that just a minute ago. But there is a question that has come up quite often that I would like Sherry to just kind of explain. We have questions of whether or not we know that legal parents and adopted and foster parents are eligible, but we get the question about what about a grandparent or another family member? So we've addressed this frequently asked question. Sherry, do you want to address that for us?
Sure. Although we know that there are a lot of informal relationships where grandparents or other family members may be caring for a child, parental leave is only available to those people who have an official relationship with the child through foster care or adoption, or it's their actual child that they've given birth to.
All right. Eligibility. When we move on to eligibility, you will see we have the requirements for parental leave. Again, one of the things that you need to make sure you're aware of is that the employee meets all eligibility factors. They must be in a leave earning position on the date they qualify for the event. We've gotten the question, well, what is a leave earning position? That's basically everything except a WAE,
Right.
a when actually employed employee. So those temporary employees would not be eligible for this particular leave. And then, as we said before, you have to have worked for the state for at least 12 months, and those 12 months do not need to be continuous, correct, Sherry? Because at the commission meeting, we had a lot of questions about how this tied with FMLA, and one of the changes that we made was to make this a little more understandable for HR and our employees, so we tied that work requirement to FMLA. You want to explain that a little bit?
Sure. The 1,250 hours is 1,250 hours preceding the date that your leave will start. When we're talking about the 1 year for eligibility purposes, like for FMLA, there's a 7-year look-back period. So if you've worked for the state here and there over a 7-year period and it adds up to 1 year, that meets the 1 year requirement. So that can be scattered over 7 years. The 1,250 hours, again, has to be in that 1 year preceding the date your leave will start.
Okay. And also got the question as well, maybe I was in an unclassified position for a period of time, and now I'm in a classified position. Does my time in that unclassified position count towards those hours worked?
It does. Any time that you work for the state will count towards your 1 year.
Okay. And also, how does it work? We got the question of when does the parental leave begin when you are fostering or adopting a child? Certainly, when a child is born, the birth date, we're here. What about fostering and adopting?
And that's a good question because there's lots of things that happen during that foster and adoption process. The leave is going to start when the child is actually placed with you. So we know there's, court proceedings and meetings and things that have to occur. That the time will start when the child's actually in your home.
And that goes back to the intent of actual bonding with a child. So, you may have to take leave for some court proceedings prior to actually getting the child placed. But once you have that child, the intent is for the bonding with that particular child.
Right. And the placement, we recognize that it takes a year for a child to be in a home, at least for an adoption to be finalized. We're not looking for a finalized adoption. We're looking for a placement where you're building that relationship and bonding with the child.
Okay. And then questions from employees that we have received is, I may not have qualified on the date the child was born, but what if I meet my 1,250 hour requirement at a later date? Would I be eligible?
The answer is no. You have to qualify on the date that the event occurs. On the date the child is born, the date the child is placed with you. It's just too hard to try to stagger that and fit other circumstances. So it has to be on the date.
Okay. And then the duration. We went over the duration. The duration can be 6 weeks up to 240 hours. That's a 12-week period, 84 days. How does that work with a part-time employee?
For a part-time employee, the number of hours is going to vary depending on their work schedule.
Okay.
So if they've worked an average of 25 hours a week, then it's going to be 6 weeks of leave at 25 hours a week, because that's what they've, historically worked.
And then labor can be unpredictable. Sometimes individuals will go in and, be there that morning and maybe in labor for a couple hours. And we've gotten this question. So kind of wanted to address this, Sherry. Do you want to touch on the circumstances, if an employee gives birth, say like at 4 p.m. on their workday, when does the leave start for that employee?
You worked, you've earned it, and that leave starts the entirety of the workday.
Yes. Okay. All right. And then what about an appointing authority when the employee comes and wants to utilize parental leave? Is the appointing authority allowed to reduce the number of hours that employee is asking for?
No, the entitlement is there. It's not variable. If you are entitled to parental leave, you're entitled to the entirety of the 240 hours.
And I thought
Full time.
Yeah, and I think that's something that we want to drive home to our HR community. When you're looking at this and employees are actually requesting leave, it's not really requesting leave. It is an eligibility that they have. The only time that you would be denying this particular leave is if the employee is not eligible, or if the employee cannot produce the documentation, which we'll get into in a little bit, to support the qualifying.
Right. And I guess the other time might be when you find out, and we wouldn't expect this to happen, but if you find out that an employee's not using the leave like they're supposed to.
Yes.
So if you're taking leave to bond with the child, and instead you've taken off to Grand Island to go fishing, that's going to be a problem.
Okay. All right. Can an employee take parental leave and carry it over to be used in the future qualifying event?
No.
All right. Okay, so Sherry, we just talked about appointing authorities actually approving or denying this leave. Generally, this leave is going to be approved because the employees are going to qualify for it. How should, when it comes to a birth, a mother use the leave? Can she use additional types of leave, accrued leave, such as sick leave? What would be in the best interest of that mother when it comes to taking sick leave or parental leave, in the order in which they take it?
Well, one of the things you may want to consider is if you are using FMLA leave. If you're using FMLA leave, you've got 12 weeks of leave. You have 6 weeks of parental leave that's paid. So what you may do if you're a mother who's just had a child is use that first 6 weeks, use your sick leave, because that's when you're going to be eligible for sick leave, and then use your parental leave. So if you use 6 weeks of sick leave and then use 6 weeks of parental leave, you've covered, they got paid for your entire 12 weeks of FMLA leave. If you reverse that, you may have a problem, because generally you're not going to be eligible for sick leave after that first 6 weeks after giving birth. So you don't want to end up in a situation where you've used your parental leave and then you can't use your sick leave. So it's just kind of a practical matter which way you want to use it to get the most mileage out of the leave that you have.
Gotcha. So could be a case where a mother may not intend to stay out a full 6 weeks, want to say for sick leave, would use parental leave for that. Okay. All right. Okay. Talk a little bit about compensation. We said that the pay was going to be at 100% of the employee's pay without any reduction to their annual leave, sick leave, or compensatory leave. Sherry, you want to talk a little bit about when we say compensation? Is it base pay? Is it premium pay? Is it shift diffs? What is included in that?
We're talking base pay.
Okay, so 100% of that employee's base pay.
That's right.
And the one we always get is, well, what if a holiday falls on the leave? Does the employee actually get the holiday pay, or are they going to be in parental leave?
They're going to get the holiday pay.
Okay. All right, moving on. Our next frequently asked question area is establishing eligibility. And this is one that we have received a lot of questions on. What type of documentation does the employee have to show? So, I have a mother who's giving birth, I have someone who is adopting. or I may have a father who wants to utilize his leave to bond with their child. How do I know they actually qualify for this? And I think we were talking earlier, and I think you said it very well, that, we're not trying to put up any roadblocks or barriers. We want this to be simple, just to provide proof that you had a qualifying event.
Right. We're not looking for multiple types of documentation. We're not looking for a lot of documentation. This is one place where our rule is different from FMLA. FMLA's requirements for documentation are much greater than what's required for this rule. We are looking for simple, minimal documentation, something that shows a relationship between the employee and the child, something that shows you're in that adoption process. That's easy. Anything from your court proceedings, you're going to have some type of documentation that shows that this child has been placed with you for foster care or adoption. Likewise, if you're going to a meeting, you're going to court document, something that shows that the meeting was scheduled. We're looking for something simple for the employee, and simple for HR to just look at and say, hey, this is what we're looking for. That relationship is there. That meeting is there. That court date is there.
All right. And certifying that, we have a form. Our rule specifically says that the director shall have a form for certifying the need for this leave. And we have addressed some frequently asked questions in that area as well. Can an agency revise that form or amend that form? It cannot be revised. It cannot be amended to meet agency-specific questions or so forth, because we need to have consistency throughout the state for all employees. It does not mean that they can't supplement that. Correct. Okay, so if they have additional information that they need for their particular agency, certainly they can supplement that request form, but need to be sure that it's in the spirit of the rule.
Exactly. Again, we're not looking for an agency to be able to request multiple types of documentation. Simple is what we're looking for.
Right. And a policy at your agency, if you feel a policy is needed, certainly you are free to develop a policy and, with procedures as far as, when you should submit something, who you should submit it to. But a policy is not required. That is strictly optional on an agency's part. And we're going to get to in a minute the actual certification form, where we'll go over that in detail, because I don't believe we've shared that form in the prior meetings that we had with our HR community. So we want to make sure to get to that during this session as well. Coding parental leave. So coding, at this time, it is being worked on with OSA. The form is not available for this session, but our staff has worked very closely with the Office of State Payroll to identify payroll codes or leave codes for employees, and how that process is going to work. We'll have that information out to our HR community soon. We also encourage those who are not in the LeGov HCM system to work with their vendors to make sure that their systems are able to code leave for parental leave as well. I know that they're working with the Office of State Payroll and the codes. We are trying as best we can to get them to identify whether it's adoption, foster, or both, or birth. So we were able to, provide data and metrics to our commission on how many people were actually benefiting for this. So be on the lookout for that. And the last area, which is Sherry's area, and I'll let her just kind of tell a little bit about questions denying the leave. And we touched on that a little bit already, but, can you still be disciplined? Can you still be separated while you're on this leave?
You can, as long as you're not being disciplined or separated because you're using parental leave. If something's going on and you need to discipline an employee, you still need to make sure that they get that due process that they are entitled to. So if they're on leave and you can't get that due process, then discipline's going to have to wait. But, it's business as usual as much as possible. But, again, it's in our rule, and it's in the spirit of the rule that no one can have an adverse impact because they've used parental leave.
Okay. All right. So, Sherry, before we go on to the forms, do you see anything in the frequently asked questions that maybe worth pointing out before we leave this section?
I think we covered most of it. But again, the HR community, people who have reviewed this rule have come up with some really good questions. I have no doubt there's stuff out there that we may still need to address. We would like to hear from you so we can go ahead and add and make sure we cover everything.
All right. So send those questions to SES Info, and we'll be happy to answer them directly to you. And if we need to, we will update our frequently asked questions. So with that, Sherry and I are going to now move to our documents and templates. If you click on that particular portion of our webpage, you will see we have the SES Parental Leave Certification Form. We also have a sample parental leave approval letter for full-time employees and part-time employees. And then we also provided you with a denial letter. These are certainly optional. You can tailor these to your agency, but we wanted to provide you with something. So please feel free to use those. But at this time, we want to take a moment to actually look at the parental leave certification form. Before we go through it, Sherry, I think we just need to mention again here about the spirit of our rule and also having accountability for our taxpayers with this certification form.
Right. We know the spirit of this rule is to grant the leave if the employee is entitled to it. We know that we've got minimal documentation requirements to make it easy for the employees and for HR to evaluate whether or not the employee is entitled to the leave. So one of the things that we do have in this form is employee certifications. And in the employee certifications, do you want to read them there?
Sure. We'll go scroll to the bottom of the page. You will see that the employee is going to initial each box. So they are attesting to these particular certifications. And the first one is, I certify parental leave is being taken because of the birth of a child or placement of a child with me for adoption or foster care and will be used in accordance with Civil Service Rule 1136.
Right. And the next one is, I shall provide documentation sufficient to establish a parent-child relationship or the occurrence of a court proceeding or mandatory meeting related to the placement for adoption or foster care. And the next one, if I provide an anticipated date of birth or placement, I shall notify my agency as soon as practicable of the actual date.
An important one, I understand that utilizing parental leave in violation of Civil Service Rule 1136 or my agency policy may result in disciplinary action, including the possibility of separation or dismissal from my position.
And I understand that any eligible family medical leave available to me shall run concurrently with the use of parental leave.
And I also certify that my statements made on this certification form are true and correct to the best of my knowledge. So the employee will sign and actually date this form. Just moving quickly right back up to the top of the form, you will see we have the information, the employee information, and then the reasons for requesting parental leave. So the employee will choose whether it's the birth of the child, the adoption, or the placement of foster care. You will see we have anticipated. We're looking for anticipated dates here. As Sherry just mentioned, we may have an anticipated date, and then the employee would notify HR with the actual date after it occurs. But we have spaces here for when the leave begins, when it concludes, also whether or not the employee will be using this continuously or intermittently. When used intermittently, we have a reason on here asking the employee to tell us why they need it intermittently and then how they intend to use it. So the goal here was to help HR and supervisors for basically handling, shifts and so forth. Sherry, if you're going to use it for a week and then come back for a week and then another week, we wanted to be able to capture that for our agency.
Right. And, you mentioned that. That's one thing we didn't talk about earlier, is you may use that week on, week off. If you have parents who both work for the state, yes. Maybe mom's going to take a week and then alternate with dad.
And they both get the full 240 hours.
As long as they both meet the eligibility requirements.
All right. And then the required documentation, the employee shall provide appropriate documentation which is sufficient to establish a parent-child relationship or the occurrence of a court proceeding or mandatory meeting related to the placement or adoption or foster care. Failure to provide that documentation may result in a delay in the effective start date of the parental leave and or the denial of parental leave. And we talked about, Sherry, some of those documents. We have those listed at the bottom. You want to share some of those?
Sure. Insurance certificate showing you have a relationship where you're insuring the child, birth certificate, adoption placement paperwork, foster placement paperwork. There's another, because anything else that shows those circumstances or eligibility will be sufficient to meet the requirements.
So, and then you have your agency approval section where you will be approving or not approving this particular request. Again, the times that you probably would not be approving this is they would maybe not meet the eligibility requirements, which we have that sample template for you to respond to the employee. Maybe they didn't provide you with the documentation. Otherwise, if they are eligible, they're probably going to be approving this leave, and we have a template available for you to use for that as well. All right, Sherry. So it looks like we've gone over the FAQs and our documents. Anything else that we need to share with the update?
I think so.
Okay.
I think we covered it.
So thank you, Sherry. Appreciate you joining me today. As we said in the beginning, this wasn't meant to be a training, simply an update to give the resources that we have for you to use as you go and administer this new rule. If you have any questions, feel free to contact us at SES Info or your consultant within our HR program support division, or even Sherry. I'm sure she will take your calls. And I would like to take a moment just to recognize that a lot of people have put a lot of work into this actual rule. Sherry and I have been talking about this for probably 2 years now. We've had legislators who have had resolutions and urged the commission to consider these rules. The governor's office and the governor's team, many people in his office have worked with us. They're working on the unclassified executive order. And it's just been a real collaborative process, and especially our HR community who's reviewed the rules that we have proposed. We made several amendments. Everyone who was involved, we just appreciate everything and all of the support that you gave our department in implementing this. And we really hope that this does make a difference for our employees. You know, that time in bonding, research has showed that it, helps improve infant mortality rates. It also helps with recruitment and retention. Employees who have access to parental leave benefits often return to their employer sometimes sooner than they would have in the past. So we're hoping this helps you in your recruitment and your retention of employees. If you have any questions, again, please contact us. So thank you very much.